Morning, Rachel. All right, good morning. Welcome to the 294th District Court. My name is Judge Chris Martin. I'm going to call the morning's docket. When I call your name, please say present or here and raise your hand so that I can make sure I mark you down as present. After I call the docket, and as I call the docket, there may be some of you who need to check in with pretrial release. I may send you at this time. I may send you after I call your case. I'll make that decision. Once I call the docket, then counsel, I'm going to ask that if you have anything that's agreed or it's going to be brief, if you'll just form a line over here to the left as you get in, that's how I'm going to call you up. Okay. Tony Ray Curtis. Tony Ray Curtis. 0 for 1. Not good. Ashley Dover or Dover. Ashley Faye Dover. 0 for 2. Batting average is going down. Nicholas Duberly. Duberly. Thanks, sir. Amanda French. Charles Howard. Charles Justin Howard. Jason Nichols. Make sure you say it loud. Shelton Vasquez. Donald Bean. Grace Fowler. Matthew Gould. Kobe Heron. Alex Maness or Maness. Alex Chad Maness, M-A-N-E-S-S. Alexis Nava. Rachel Powell. Carlton Mitchell. I have a confirmation that the defendant is in the Smith County Jail. Is that right, Mr. Ashworth?
Yes, Your Honor.
Okay. All right. I'll call him in just a minute, then we'll get you gone. Okay. Don't let me forget you. Okay. Alton McCurley. Ashley Olds. Wilbur Bear. Thank you, Mr. Ross. Devin Key. Sean Kuntz. Christian Dickinson. Zachary Bird. Tracy McGahee. Tracy Renee McGahee. Hunter Tapper. Cannon Rackow. Cannon Nash Rackow. Tiffany Stevenson. Wendy Adams. Lindy Delaney. Nathan Sampson. Brendan Chumley. Brendan Hugh Chumley. Thank you, Snowell. Tasha Messick. Lena Price. Kristen Lewis. Kristen Laurel Lewis. Bill Adams. Bill Adams. Jason Hudebeck. Douglas Mercer. Justin Reed. John Rigney. Thank you, Mr. Schmidt. Skylar Tanner. Is Mr. Tanner going to be a plea today? Okay, thank you. Cleela Roden. Tony Burgess. I'm sorry, Troy Burgess. Okay. Billy Gammons. Thank you, Ms. Thompson. Aaron Blevins. Jaime Zarate. Adrian East. Kyle Holland. Kyle James Holland. I'm sorry, that's set at 11. Is there anyone who's in the courtroom whose name I have not called? Your name, sir? Yes, Mr. Bear, I called that earlier. William Bear? Thank you, Mr. Bear. Anyone else? All right, Mr. Ashworth, I'm going to call CR 2349, State versus Carlton, Wendell Mitchell. And as I said, I think we were set today on its status for if he was in custody. He's still verified to be in Smith County. Do you have any information for the court on his custody?
No, Your Honor. He's not even indicted yet. I just know he's still there. His 90 days will be about June 9th. I'm not really sure they'll indict him within the 90 days, but past experience tells me they probably will.
Okay. All right. Well, let's set him past that June 9th date. If you have your calendar available, go ahead and take a look at that.
Okay.
How about July 1st? Are you available on July 1st? If not July.
Judge, I am supposed to be in trial that week. Are you available July 2nd? Do y'all do docket on Fridays?
No, I've got July 1st. I got July 8th.
July 8th would be great.
That'd be fine. Okay.
Yes.
We'll set Mr. Mitchell then for another status on his custody on July 8th. If he is in custody still, or he's released and Van Zandt County takes custody of him, and he's not out on bail, then the court will set that at 1:30. It'll be a 1:30 hearing, as all the jail cases are heard in the afternoon. Okay.
Great.
Make sure you know that if he gets released, let's say that they don't indict him, he gets a PR. I don't know if he's on bond here or not. If he is, it'll be at 9 a.m. So.
Okay, Judge. And he won't PR bond out no matter what. He's being held on a blue warrant. So,
okay. So
he'll be in custody somewhere.
Okay. All right. Then we'll just, we'll set it again for status custody on that July 8th date. And then if he's back in our custody on that day, just know it'll be at 1:30. Okay.
Great. Thank you.
You're welcome. Mr. White.
Yes.
You ready?
Yes.
Who are you ready on? Jaime Zarate, CR 2278. If you'll come to the middle podium, please. All right, Mr. Zarate set for docket call today. Is that correct?
This is called feedback. This is going to be played. It's like asking for recess. Judge, that is
the only concern I have about Mr. Zarate is he does not report on pretrial release. He pays, but he never takes the time to go over there and be seen as ordered. So I'm wondering why I shouldn't put him in jail. I understand it's going to be a plea, but I'm wondering if maybe I shouldn't put him in jail and hold him there until the plea is ready. Mr. Zarate, I'm going to order you to report to pretrial release as soon as this hearing is over. You understand?
Yes, sir.
You understand, and Mr. White's going to make sure that it's clear to you, but I'm going to do that right now. If you don't do what I tell you to do, I'm going to find your bond insufficient. I'm going to put you back in jail and you'll sit there until I'm ready to do the plea. You think that's what's best for you? Okay, I'm serious. Mr. White, how long do you need for the plea, you believe? Okay. All right, Mr. Zarate, the court's going to set you for plea on July 8th at 9 a.m. Is that all you have this morning, Mr. White? Thanks, sir. Yes, sir. Right. Yes, ma'am. Or yes, sir. I'm sorry. Mr. East. Mr. White, if I can just have Mr. Zarate step to the side, I'm going to bring Mr. East up. All right, this is CR 2244, State versus Adrian Ladon East. Go ahead, Mr. St. Julie. Okay, so you followed the motion to suppress. Do you want an evidentiary hearing on that?
We're still talking about some preliminary issues on this. We're allowed pre-trial. Mr. Will be able to follow the motion, but I have not had.
I show that we're set for a docket call today. Have we not already passed pre-trial?
Judge, Mr. St. Julie is new to this case. Mr. East had a previous attorney. This either the first, second. I know we only spoke about it, but he's fairly new to this case. We wouldn't be opposed to pre-trial.
Okay, so what I'll do is I'll maintain the docket call. And then if the state agrees or there's good cause shown for the pretrial, then we'll set it for a contested hearing. But right now we'll just set it for another docket call.
And Judge, that July 8th.
What is today? Today's the 25th. I do have something earlier. I've got July 1st. It'd be in the morning.
July 1st.
Okay. All right, Mr. East, we're going to set you for July 1st at 9 a.m. And Mr. St. Julian is going to bring you a notice slip to sign. Once you receive that, then I'm going to order you to report to pretrial release to sign some additional paperwork. Okay. Kristen Lewis, CR 2181.
Judge, just a quick note, the phone number I have is no longer working.
Okay, so she's still not here. Okay. Yes, thank you, Mr. Sanders. He needs to report to pretrial release. And I'd go with him, Mr. St. Julian. There's going to be conditions on his bond. And Mr. East, you can come on back this way and right through this door right here. They'll help you out. Aaron Blevins. Good morning, Mr. Wells. Doing great. This is CR 16-8, hearing on motion to revoke, I believe.
Right, we're working this out, Judge. We just need to reset. Steve, and it would like one reset for him to provide some information to them.
Mr. Woodwike or Ms. Heisel, any objection to continuance on Mr. Blevins' motion to revoke?
If he's here.
All right, how long do you need, Mr. Wells?
30 days. Or,
You good on July 1st?
most likely. I'm good.
All right, Mr. Blevins, the court's going to set you on July 1st at 9 a.m. Does he have a reset slip?
Right.
All right, good. Go ahead. Has he signed
He
it?
signed it.
All right, just rip that up here. You need to put the date right there,
Yeah.
July 1st at 9 a.m. And then leave me the white one, give him the yellow one, and he'll be good to go. Mr. Blevins, you still reporting on probation? You understand? You need, make sure that you're still under your conditions of probation. Still required to report, pay, drug test, all those things. Just because they file a motion doesn't mean that you walk away until the hearing's had, okay?
We're gonna get him, Judge. I'm gonna talk to Rachel or Karen about getting him back in because he has missed before.
Okay. Mr. Wells is working on that for you. Jason Hodebeck, CR 2121. Mr. Hodebeck set for pretrial today.
That's correct. Yes, we received the discovery done.
You available on July 1st at all, Mr. Schmidt? All right, we'll set Mr. Hodebeck then for docket call on July 1st at 9 a.m. Yes, Mr. Hodebeck, you're free to go. Douglas Mercer. This is CR 2264, State versus Douglas, Keith Mercer, and we are set for docket call today. All right, before I set the case, Mr. Mercer, I show that you are delinquent on your conditions of pretrial release. $100 this morning. Problem is, I show you're over $1,000 delinquent. I want you to come over here and have a seat. I'm gonna have you drug tested this morning. Just have a seat right over here. And I'll recall your case in just a moment. Justin Reed, CR 2406. Show Mr. Reed set for pretrial today. All right, court will set Mr. Reed then for docket call on July 1st at 9 a.m. Mr. Reed, after you sign that, I need you to report to pretrial release to sign conditions of pretrial release, okay? All right, court calls CR 2307, State versus John Brendan Rigney. I believe, Mr. Schmidt, you have some information for the court on your client's absence today.
Also, I believe that getting some additional discovery, I think, so moving forward on the 1 and 2. So visual evidence.
Any objection from the state?
No, Your Honor, they are working on it. The PD had to, focus and outsource people for technology events.
Okay, all right, the court will set Mr. Rigney then for docket call on July 1st. Mr. Schmidt, what I'm going to do for Mr. Rigney is on the NISA, I'm going to take it under advisement until 5 p.m. tomorrow. And what I would ask him to do is to call my coordinator, criminal coordinator, Ms. Taberham, and set up a Zoom appearance where he could just check in with her via Zoom. All right, we're still waiting on paperwork for Mr. Tanner. And Bill, is Mr. Adams still on his way?
He should be on. Double check.
Clelo Roden, CR 2357. All right, Ms. Roden is set for docket call today.
Yeah, Judge, I think we're in this case.
Okay. How long can we play it today?
We're still kind of through a couple issues there, so 30 days.
Are we waiving jury today and setting it for a plea, or are you asking for a reset of 30 days?
I would say that still as a client, we are very close on agreement on this. So if you want to do less than 30 days reset, they can be fine with that.
That's fine. I am set trial push in June, so
How about June 15th?
that'll work. Is that gonna be Monday? Tuesday?
Tuesday.
That's fine.
All right. Ms. Roden, the court's going to set you for a plea on June 15th at 9 a.m. Do you have the notice form for her to sign? Has she already signed?
I'm sorry, I think I got
Yeah, if everyone's signed, I'll take them.
Mr. Mayor,
Thank you, sir.
Mr. Mayor, it's a hard hearing. There is no way he will hear you.
Okay, we may bring him up then closer. Thank you for the heads up. Yes, sir. Yeah, go ahead. You got to fill all that out on the bottom. The reset date, time, today's date. All right, Mr. Roden, just step over to your left real quick. I'm going to call the next case and then Mr. Steele can have you. Once she signs and give her the yellow copy and the white copy will stay here. No. Joe. Mr. Bear. All right, this is cause number CR 20322, State versus Wilbur Wayne Bear. Mr. Bear, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you may put your hand down. Are you Wilbur Wayne Bear? And Mr. Bear, are you a United States citizen?
Yes, sure.
Do you read, write, and speak English?
Yes, sir.
And have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Files. Are you pleased with his representation of you?
Oh, yes, sir.
Do you feel like you've had enough time to talk with him about your case and have all of your questions answered?
Yes, sir.
Is there anything about the paperwork that you read and reviewed and signed today that you do not understand?
No, sir. I understand.
All right. Mr. Files, do you believe your client to be competent today?
Yes, Your Honor, I do.
And have you explained to him his legal and constitutional rights?
See the fail, Your Honor.
And have you also advised him of the advantages and disadvantages of a deferred adjudication plea?
Yes, Your Honor, we have.
Mr. Bear, it appears to me that you're going to be pleading guilty to a Class A misdemeanor offense of deadly conduct in exchange for the state's recommendation that a finding of guilt be deferred on that lesser included offense, that your punishment be assessed, or I'm sorry, that your punishment be deferred, and that you be placed on 2 years community supervision with a $2,000 fine. In addition to that, you'll have to pay court costs of $270 and reimbursement fees of $35. Is that your understanding of the plea?
Yes, sir.
Yours as well, Mr. Files?
Yes, Your Honor, it is.
Mr. Bear, you were originally indicted with a second-degree felony offense of aggravated assault with a deadly weapon. However, the plea today is to a Class A misdemeanor deadly conduct, which carries a range of punishment of not more than 365 days in the Van Zandt County Jail and a fine not to exceed $4,000. Do you understand that range of punishment?
Yes, sir. I do.
That means that if the court approves this today and places you on community supervision, if you subsequently violate your conditions of community supervision, if the state proves that to the court, after a hearing, the court could revoke your community supervision, could convict you of this offense, and could assess your punishment anywhere between 0 days and 365 days and assess a fine between $0 and $4,000. Do you understand that?
I do, Your Honor.
And you want to go forward with this plea?
Yes, sir.
Okay. All right, then to the Class A misdemeanor charge of deadly conduct, how do you plead?
Guilty.
And Mr. Bear, are you pleading guilty because you are guilty of committing that offense?
Yes, Your Honor.
And Mr. Files, well, let me ask you this, Mr. Bear, has anyone threatened, forced, or pressured you to plead guilty today?
No, sir.
And Mr. Files, any objection to State's Exhibit 1?
Objection to exhibits marked in office.
State's Exhibit 1 is admitted into evidence, and the court does take judicial notice of the defendant's judicial confession. Anything further from the state? And the court's going to inquire about victim information on this. Anything further from the defense? Ms. Heisel?
Your Honor, the state is in victim compliance. There was no response to our packet for EIS.
Thank you, Ms. Heisel. Anything further from the defense?
No, Your Honor.
I'm going to take just a moment and look at the evidence in the case. All right, based on the court's review of the evidence, I do find that there's enough evidence to convict Mr. Bear of this offense. However, the court will follow the plea agreement in this case. The court defers a finding of guilt, places Mr. Bear on 2 years community supervision, assesses a $2,000 fine, orders Mr. Bear to pay $270 court costs and $35 reimbursement.
May I?
Yes, please.
Bear is a retired minister and is not economically advantaged. The question is, who can pay it out?
And you addressed that with him?
Yes, Your Honor, we did. Also, he mentioned that on occasion there might be people who have been convicted of offenses who would be in church and regulations and whatnot to be concerned about that.
Yes, court would not consider that associating,
Yes, Your Honor.
and that would be the best place for them to be anyway. In my opinion. All right, Mr. Bear, I'm gonna have you step to the left to be fingerprinted. After that, Mr. Files, if you'll make sure that he sees probation department here with Ms. Burns, and they'll go ahead and give him additional information.
We have three unconventional announcements.
Okay, I'll call this just a second.
Mr. Harrison, I've been funny, well, I'm also Mr. Harrison for today.
Yeah, that shoe's been on the other foot quite a few times, hasn't it? He's been Mr. Files several times. Thanks, sir. Let's don't do it right now, just because I've got more, but if you'll let Mr. Files know, then maybe we can arrange that afterwards. Devin Scott Key. All right, this is CR 2292. Set for docket call, Mr. Files.
Yes, Your Honor, Ms. Curry and I have been busy about this case. We've done a preliminary investigation. There is one expert that he needs to see, and there is some additional investigation that needs to be done. There is a possibility we can have it in 30 days. Of any objection, we're saying at that time, this would like the cost.
State.
That's correct. It's okay.
We may not, we may have to come back and we're not quite ready, but because of the court, that's where we are.
Are you available on July 1st?
Yes, Your Honor.
All right, Mr. Key, the court's going to set you for an additional docket call on July 1st at 9 a.m. Once you sign your notice of setting, I need you to report to pretrial release. I show that you haven't reported since being placed on conditions of pretrial release. So once you sign your notice, just step over here, the officer mature, and she'll give you additional information. You have a notice form for him to sign? You have a notice form for him to sign? Okay, he'll need to sign that before he leaves. Him yellow copy, us white copy. 9 a.m. Mr. Key, you can just have a seat right there on that front row. It's fine.
Also, have Coons and Tacker.
Sean Coons, CR 2346. Mr. Coons set for pretrial.
Yes, Your Honor, we recorded his correction. I may have said it into a record on this telephone call to the court case. She advised me that there's still some investigation she wants to do. And obviously, we have no objection to that, but that's same time, July 1st.
Any contested pretrial issues, motion to quash, motion to suppress, and but no motions have been filed.
No motion.
All right, there being no pretrial motions that need an evidentiary hearing, the court sets Mr. Coons for docket call on July 1st at 9 a.m.
There is a possibility. One motion.
Okay. And did you say, did Mr. Harrison have any today? Hunter Tapper, CR 2371. Mr. Tapper set for docket call.
drug case that is on the court's docket. However, there is a more serious case that is in intake. Ms. Curry, I've been issuing about that. I am hopeful that we will be able to resolve both cases without the necessity of trial. But I would ask that if we could have a little more than 30 days after July 1st to see where we go.
You may.
Yes, that's correct.
All right, Mr. Tapper, the court will set you for an additional docket call hearing on July 15th at 9 a.m. Once you sign the notice of appearance form and get the yellow copy, you'll be free to go. Yes.
After we get those signed, excuse me.
Yes, yes, sir. Yes. Ms. Thompson.
All right, Mr. Burke is present now, and ready to go forward with that.
Mr. Burgess. Mr. Burgess Senior, you can come and assist him. And just keep it, yeah, right there. Just tell him to hold on right there. Right there. There we go. Let us deck. All right, this is CR 21-8, State versus Troy, Wayne Burgess. Court has reviewed the pretrial motion for evaluation filed by Ms. Thompson. Court has granted that. Court has appointed the Honorable Dr. Timothy Ingram to conduct an evaluation. So Mr. Burgess, you're going to be contacted by Dr. Ingram, and he's going to want to talk to you and ask you several questions. And so I just ask that when you meet Dr. Ingram, if you'll just talk with him and give him some information about you and your condition in your case. And then that information will be given to Ms. Thompson and to the state and to the court, okay? So what I'm going to do is just reset the case. Are you available on July 1st? I'm sorry, let's do, how about July 8th? Are you available on July 8th, Ms. Thompson? Is that fine? Okay, I think that should give us enough time. So Mr. Burgess, I'm going to reset you for July 8th. Ms. Thompson's going to give you some paperwork that's going to have that date on there. Just sign that and give that back to her. And then Dr. Ingram will be in contact.
Maybe request prior to the proper release information. So it looks like a release should be.
For Mr. Burgess's, okay. Get that file and the court will sign that. He's so good. He's so good.
So that they excused.
Yes, thank you, Mr. Burgess. Thank you, Ms. Thompson. I believe.
I have one more.
Okay.
Recall Billy Gavin.
Okay, I'll call him in just a moment. So, CR 2164, Billy Cody Gammons. Is Mr. Gammons here?
Sir,
Mr. Gammons here?
no,
Oh, I thought you said recall because he was here. Okay. All right, court will issue a judgment not for Mr. Gammons.
because it's all I have.
Yes, thank you, Ms. Thompson. Okay, let's see the pro. Mr. Gimbel, you ready? Mr. Byrd? This is CR 2148, CR 21108. Mr. Byrd is set for arraignment today. Is Mr. Harden here? All right, Mr. Gilmore, are you aware that Mr. Harden has filed a motion to substitute counsel?
No, I'm not aware of the state and informed me that there were option work for the possible plan, but I did not receive confirmation of that.
What were you saying, Mr. Byrd?
So, what I said was I'm trying to work with
So you haven't retained him yet? All right. So Mr. Byrd set for arraignment today, Mr. Gimbel.
That's correct, Your Honor.
Have you had a chance to speak with him about the indictments and?
We have a copy of the indictment. His name is spelled correctly on the indictment. He understands the charges against him and enters a plea not guilty.
All right, court will enter Mr. Byrd's pleas of not guilty into the record for each cause. Court will also set Mr. Byrd for pretrial hearing. Are you available on July 1st, Mr. Gimbel?
Yes, Andy.
All right, Mr. Byrd, you're set for pretrial on July 1st at 9 a.m. If you do retain Mr. Harden, then Mr. Harden's aware that he'll be filing a motion to substitute counsel, and you'll have to give that notice to Mr. Gimbel as well. All right, we'll see you back on July 1st at 9 a.m. Yes, Mr. Waddell. You, is Tracy Renee McGahee here? Tracy McGahee.
My head contact with the VP for the last phone number I had is no longer active.
All right, Mr. Gimbel, you're free to go. If he shows up or she shows up, same will not be said. You're free to go.
Thank you.
Olton McCurley, CR 21A2. Mr. Bingham, will you approach, please? All right, this is CR 12A2 State versus Olton Dean McCurley, hearing today on the defendant's motion for early termination. I understand that the defendant and state have an agreement to withdraw that request and to continue negotiating, and there may be possibly something submitted to the court later with regards to the same. Is that correct?
That's correct, Judge. We've asked the court's permission to allow us to withdraw that motion. We just what the court said, we're talking to Missouri, hoping to present something for court to consider on the conditions.
Okay. All right, court will grant the request and we'll find that the defendant has withdrawn the motion for early termination.
Thank you, Judge.
All right, thank you, Mr. McCurley. You're free to go.
That's all I have. Excuse me.
Yes, thank you, Mr. Bingham. Appreciate your patience. Do we have a result on Mr. Mercer? Is Mr. Waddell available? So I'm assuming he was positive for something. Oh. So they're just gonna send it in. They're gonna send it in for the initial testing. Do you have information on Mr. Mercer? On the UA? Were you ready on? Mr. Mercer, CR 2264. All right, the court had previously called Mr. Mercer for docket call, received the defendant's announcement. Court expressed concerns with the pretrial release conditions, specifically the delinquency and financial payments for bond supervision and attorney fee reimbursement. The court also ordered a urinalysis on Mr. Mercer. Mr. Schmidt has disclosed to the court that there was some concern that the probation department may have had with regards to the disclosure by Mr. Mercer of some prescription medications that are going to require lab report from, or lab testing rather than field testing.
Yes, sir.
Okay.
I asked the defendant if there would be anything in the system, and he immediately told me that he takes medication that has 3 times fast shown toxic.
Okay. And so you've collected a sample today?
Yes, sir.
We're going to send that off to the lab.
Yes, sir.
Okay. All right, Mr. Mercer, and you said that you paid $100 towards your pretrial fees? All right, so I appreciate that, but you're still delinquent quite a bit. If you don't get on top of it, unfortunately, you're going to make me get on top of it. Okay? All right, court's going to reset at council's request, the docket call. I didn't give you a date, did I, Mr. Schmidt? I think I previously set you for July 1st. Is that fine?
Yes, sir.
All right, court sets Mr. Mercer then for docket call on July 1st and also status on UA. You can, just, I mean, I'm not gonna do anything about it today, but we'll tell me that you check on that, we just make notes. Bill Adams, CR 2283. Mr. Adams, you were not here at 9 a.m. when I called your case. I try to get out here at 9 a.m. and do my job. I expect you to be here. You understand? But if it weren't for Mr. Schmidt employing the court to give you another chance, you might be going into custody right now. You understand? You understand? Go ahead, Mr. Schmidt. We're set for a docket call today. All right. Can you disclose to the court what the offer is or was?
I know that. I don't remember. I'm not sure.
No, I just wanted on the record that there was an offer made, that it was disclosed, that it was rejected, and that he selected jury selection.
Judge, I believe, Mr. Cox did for finding it, but it was our understanding that Mr. Adams was not going to take it. There was an offer made, it was rejected.
But what was it? What I don't want Mr. Adams to go to trial and find out the offer was 2 years and him say, I would have taken that, or the offer was deferred and I would have taken that.
Judge, we would offer him either.
Do you want me to recall it? Let me give you all a moment to recall.
Judge,
All right. All right, Mr. Adams, just have a seat right there on the front row. That's fine. Mr. Manning, are you ready?
So we are arguing for this French, I just point out her case.
Amanda French, CR 2162. Ms. French, you requested court-appointed attorney. The court reviewed your affidavit of indigency, has found you to be indigent today, has appointed the Honorable Jonathan Manning to represent you. You met with Mr. Manning today. Mr. Manning, we're set for arraignment. Go ahead.
Yes, Judge, I've gone through the indictment with my client, name is spelled correctly, she understands the charge against her, and at this time, she's pleading none.
All right, court will enter Ms. French's plea of not guilty into the record. We'll set this for pretrial. Are you available on July 1st, Mr. Manning?
Judge, actually, I am, previously scheduled.
Do you want to check with Ms. French to see if she has any concerns?
Judge, given the nature of this case and the discovery that we have a little bit longer on that pretrial.
About July 8th.
That'll work, Judge.
All right, Ms. French, court sets you for pretrial on July 8th at 9 a.m. Once you sign the notice of appearance, you'll receive the yellow copy. Mr. Manning, do you know if Ms. French has signed her conditions of pretrial release?
I do not, Judge. I asked her if she had finished the pretrial release, and she was unaware that they were ready.
All right, so once you sign this and get your yellow copy, Ms. French, then just come over here and have a seat, and they're going to give you some additional paperwork to sign. And then after that, you'll be free to go. So this is Amanda French. Is Mr. Rackow here?
Judge, he is not, and he also failed to appear to get the misdemeanor docket earlier this month. I've been unable to get a hold of him. So I'm unaware.
I will send out a search party.
Thank you.
Are you ready on Tiffany Stevenson?
We're still waiting on the work, I believe.
Okay.
It's in the works. Judge.
Okay. Okay. Mr. Knoll, you ready? Tasha Messick, CR 2185. All right, Ms. Messick, if you'll raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can put your hand down. You are Tasha K. Messick. Ms. Messick, are you a United States citizen? Do you read, write, speak English? Have you ever been diagnosed with any type of mental condition? Okay, because I can see you shake your head, but my court reporter has to be able to type down what you say. Okay. And for the record, she said no to the mental health question. Ms. Messick, in this case, you're represented by your attorney, Mr. Kurt Knoll. Do you feel like you've had enough time to talk with him about your case and have all your legal questions answered? Is there anything about the paperwork that you've read and signed here today that you do not understand? Mr. Knoll, do you believe your client to be competent today? And have you explained her legal and constitutional rights to her? Ms. Messick, you are charged by indictment with a state jail felony offense of driving while intoxicated with a child under 15 years of age. A state jail felony in the state of Texas carries a range of punishment of not less than 6 months or more than 2 years confinement in the Texas Department of Criminal Justice, and also carries an optional fine not to exceed $10,000. Do you understand that range of punishment? I see here that there is a plea agreement wherein you would plead guilty to that charge in exchange for the state's recommendation that your sentence be assessed at 15 months confinement in state jail with that sentence being suspended and you being placed on community supervision or probation for a period of 2 years with a $2,000 fine, $60 restitution, court cost, and $535 reimbursement fee for Mr. Knoll's legal representation. Is that your understanding of the entire plea agreement?
Yes.
And that's what you want the court to approve today? All right, Ms. Messick, then how do you charge to that plea? I mean, I'm sorry, how do you plead to that charge? Got that backwards. And Ms. Messick, are you pleading guilty because you are guilty of committing that offense? Has anyone threatened, forced, or pressured you to plead guilty? All right, court will accept Ms. Messick's plea of guilt at this time. Mr. Knoll, any objection to States 1?
No, Your Honor.
All right, States 1 is admitted into evidence and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
Thank you, Mr. Woodwhite. From the defense?
No, Your Honor.
All right, based on the court's review of the evidence, I find there is sufficient evidence to convict Ms. Messick of this offense. Court will follow the plea agreement. Court finds her guilty, assesses her punishment at 15 months state jail. Court will suspend that sentence and place Ms. Messick on 2 years community supervision. Court assesses a $2,000 fine, orders $60 in restitution, orders her to pay reimbursement fees of $535 and court cost of $290. You may. Court's also completing the trial court's certification of the defendant's right to appeal. Court finds that this is a plea bargain case and the defendant has no right to appeal. All right, Ms. Messick. I feel a need to point out to you that after reading this, very disturbed. 2 young children in the car and you make the decision to drink and drive. I don't know where you're at in your life now, but I know what part of your life you're about to be in. I'm about to be a big part of your life. And you're going to know me through this probation department, through your probation officer, okay? And you know what? I love baseball. I love baseball, but we're not playing baseball here. There's no 3 strikes. All right, so don't go over there and screw up probation and then come over here and ask for another chance, because it's just nonsensical. Drinking and driving, period, one. Getting behind the wheel of a car. If you want to endanger your life, you can go out and figure out a way to do that, to not endanger anyone else, me, my family, or anyone else that drives here. But are those your daughters? Are those your kids? I don't know if you have a lot of guilt over that, but you should. Well, you should. Especially, I mean, a 13-year-old has very little control over what her mother does, but a 7-month-old or a 2-month-old, whatever she is. Come on now. It is bad. So I'm going to tell you this, if you get over on probation and you screw up, I guarantee you this, I'm going to go back. If it's a year from now, or let's say you're going to be on probation for 2 years. If it's 1 year and 11 months from now, and you miss an appointment, you don't pay, you don't do your community service, and they file a violation, I'm going to go back, I'm going to read this. And you said that you're going to do 15 months, and you're right, you will do 15 months. And that's day for day. No probation, no parole. All right. Hereby remand you to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the sentence. I want you to come forward and have your fingerprint and then step over here with probation. All right, the court's reviewed the evidence and I find that there is sufficient evidence to convict the defendant of this offense. Court will follow the plea agreement. Court does convict Ms. Price of the third-degree felony offense of fraudulent use or possession of identifying information. Number of items, 5, but less than 10. Court will assess her punishment at 10 years confinement in the Texas Department of Criminal Justice. Court will suspend that sentence, place the defendant on 5 years community supervision. Court orders her to pay a $2,500 fine, $290 court cost, $785 in reimbursement fees. Court also finds that the state is taken into consideration with the plea in this case, unfiled DWLI and unlawful use of criminal instrument. You may. Thanks, sir. All right, Ms. Price, you're hereby remanded to the custody of the Van Zandt County Community Supervision Corrections Department so they can carry out the terms and conditions of the sentence. I'm going to have you step forward to be fingerprinted with the bailiff. After that, I need you to step over here through these doors to speak with the community supervision officers. Yes, thank you, Mr. Knoll. Those are those 2 plates from Mr. Knoll. I just forgot to add them in there. Christian Dickinson, CR 13-6. How are you, Ms. Fox? All right, we are set for hearing on Ms. Dickinson's motion to revoke.
Yes, sir. I've been discussing the case today and we haven't been set for contested revocation, however, I think there's a very, very strong possibility that we will have to solve.
Did y'all agree on a date or June 29th?
June 29th is what the state proposed. I believe that the stocks not going to work out. And the state will work. If we don't work out that, I'm hopeful that we will.
All right, court will set Ms. Dickinson then for contested hearing on June 29th at 9 a.m.
Thank you. And we will be here. Nice meeting you.
Nice to meet you. Ms. Dickinson, remember, you're still on probation. You still have to report drug test. Yes. Just because a motion's been filed doesn't mean that you're not having to comply with orders of the court. So it'd probably be very wise to meet with probation today to find out if you need to do anything. Okay? Mr. Leader, are you ready? Wendy Adams. All right, this is CR 19-129, CR 19-130, State versus Wendy Gale Adams. States filed a motion to dismiss in both these cases. Is that correct?
That's correct.
All right. And the court finds that Ms. Adams has paid $1,000 towards her arrearages on the conditions of pretrial release. Court does appreciate that, Ms. Adams. Court hereby grants the state's motion to dismiss. I believe those are in e-file, so I'll get those signed today. So you're free to go. Thank you, Ms. Adams. Lindy Delaney, CR 2399, CR 21150. All right, Miss Delaney is set for docket call today, I believe. Also, Mr. Murleader, you filed a motion of withdrawal as counsel, is that correct?
That's correct, Judge. I haven't been approved of the new case. As the motion states, it's trying to get in contact with these claims and get her into our office to at least review the discovery for the second degree felony. The plea offer on that is 10 years to the CJ. I've talked to the state numerous times. They're pretty hard set on request TCA time for her. I don't see negotiate change that judge. So this is most likely to be jury trial. And I have not been able to sit down with this case or any of the discovery for the second degree felony. Why I asked the question. Today's actually the first day I've seen her in about 5 months. She was sick for at least 2 prior doctor calls. She was tested positive for COVID. But prior to that, I asked also if she has been able to I'm not able to make it whether we're going to jury trial or not without having discussed the case. That's my message.
Ms. Delaney? And I can't hear, all I hear is mumbling, so speak up.
I'm sorry.
Did you hear what Mr. Murleader said? You heard him state what the offer is. You heard him state that it's going to be very hard for him to represent you at trial, to give you a zealous defense, to be able to cross-examine the state's witnesses and their evidence if he can't have your assistance in forming a defense. So what do you propose, Ms. Delaney? Mr. Murleader, here's my concern. If I allow you to withdraw as counsel and appoint someone else, and she treats the next person the same way, justified or not justified, then the state's never able to go to trial. If the defendant elects not to take part in forming a defense in their own case, they could basically stall out the state's case. So that's my concern with allowing you to withdraw. I certainly understand your position, Mr. Murleader, and I would not want to be in that either. It'd be very difficult, I think, to provide a defense to someone who's not telling you anything about their case. But nevertheless, I think that's what we're going to have to do in this case. If she chooses not to assist, court can't grant the motion to withdraw at this time for that reason. So I'm gonna deny the motion to withdraw. And I'm just going to warn you, Ms. Delaney, and I understand if you've been sick, but you've got to contact Mr. Murray. He says it's been how many months, Mr. Murray, since you've heard from her?
Well, I've heard from her text messages, Judge, it's just that I haven't met with her for about 5 months.
So, Ms. Delaney, you've heard what Mr. Murray said the offer was, and yeah, we're set today for docket call. And docket call is when I need to know from you whether or not you're gonna accept their offer or you're going to ask for a bench trial or a jury trial. So, Mr. Murray, now that the court has denied your motion to withdraw, would you like the court to grant you another docket call appearance with Ms. Delaney now that she said that she can meet with you and determine in the next 30 days if she's able to assist you in reviewing the evidence so that you can get to a point where you can announce whether or not it's going to be a plea or a trial?
Yes, Your Honor. And I would also ask the court to appoint me on new lead case, CR 21-001. That's a state judge felony, set for arraignment today. This lady has had an opportunity to review that indictment. Her name is all that. We'll enter a plea not guilty to that.
All right, Mr. Murray, I show that you were appointed to the 2 charges, a state jail debit or credit card abuse, and also the CR 2399, both on September 15th, 2020. Is the credit card, debit card abuse, is that what's reflected in the indictment in CR 21150?
No, Your Honor, the credit card abuse case was dismissed on payment of restitution by an agreement to Ms. Delaney and the state, and these 2 new charges that came out after that were not included in that agreement.
Okay, all right. The court will appoint the Honorable Shravnesh Murray to represent Ms. Delaney in CR 21150. Court will find that Ms. Delaney's name is spelled correctly in the indictment, that she understands what she's charged with, and that she enters a plea of not guilty. Court will enter that into the record. Court will set the new case for pretrial. Are you available on July 1st or 8th, Mr. Murray?
Judge, I'm in a hearing for a writ of habeas corpus on July 1st. What I said July 8th.
Okay. Court will set the new case for pretrial on July 8th. Court will set the drug case for docket call on July 8th. Both at 9 a.m. All right, so Ms. Delaney, it's going to be very important for you to be in contact with Mr. Murray, not just by text messages, but you're going to need to make a decision that's going to affect your life, whether or not you ask for a court-appointed attorney, and this court has given you one. And it would be very dumb to not take advantage of what's been provided to you in Mr. Murray's knowledge and skill in the law. You understand? So if you want to sit back and not help him and not do anything, then you're not going to be able to come in here and complain about it when the trial happens. And it will happen, okay? So if you're feeling better now, then this is your opportunity to carve out some time in your life and go meet with Mr. Murray and let him give you what you've asked for. All right, once you sign that, you'll be free to go, but I want you to come back and meet with the probation department on some issues with your conditions of pretrial release. Just meet with them, and then whenever they're done with you, you'll be released, okay? Nathan Sampson, CR 2135. All right, this is CR 2135, State versus Nathan Joseph Sampson, set for pretrial today.
Judge, we received all the discovery and reviewed all the items after discovery. From the chief's office. And this is basically offer 5 years TCJ. So that's for concept for non-conform. The state has asked us for additional information, so the negotiations are ongoing. I intend on getting that information. There's a highlight in your honor of this case being resolved. This time we have to pre-launch.
All right, there being no contested pretrial motions, the court will set Mr. Sampson for docket call on July 8th at 9 a.m. All right, once you sign, Mr. Sampson, you're free to go. Yes, thank you, Mr. Marley. Mr. Schmidt, are you ready? Mr. Adams? Mr. Adams? All right, we're back on the record, CR 2283. Court was just wanting to know if there was an offer and if that offer is rejected, so we can get that on the record and then we'll get our jury selection date.
This junk offer to PDC.
2 years TDC or 10 pro 10. All right, court finds that Mr. Bill Adams has rejected the state's offers of 2 years confinement in the Texas Department of Criminal Justice, or alternatively 10 years community supervision on a straight probation with 10 years supervision. Court hereby sets Mr. Adams on the court's jury selection docket beginning June 7th. So Mr. Adams, on June 7th, you're going to report in the basement of the courthouse at 8:30, and a member of my staff will be down there to assist you with paperwork. Mr. Schmidt's not going to be ordered to be there because your case is not going to be reached for trial on the very first setting. So you're going to continue to come until your case is reached for trial. Okay. All right, you're free to go. Let's do the arraignment. Was Howard appointed or retained? Okay. Charles Howard, CR 2176. All right, Mr. Howard, the court has reviewed your application for court-appointed counsel. Court finds you to be indigent and has appointed the Honorable Richard Schmidt to represent you. I believe you met with Mr. Schmidt this morning. And Mr. Schmidt, we're set for arraignment today. Go ahead.
Correct, Judge. We received a copy of the document I got on that, Mr. Allen. His name is correct.
All right, court will enter Mr. Howard's plea of not guilty into the record. We'll set him for pretrial hearing on July 1st at 9 a.m. Mr. Howard, I'm sorry, one more thing. Can you come back and meet with pretrial release? They've got some additional paperwork for you. I forgot to let you know that. Just come on back here, go around and come back through this door. Skylar Tanner, CR 2312. All right, Mr. Tanner, if you'll raise your right hand, I'm going to place you under oath. Mr. Tanner, do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth, so help you God? All right, you can put your hand down, sir. Mr. Tanner, you are Skylar Matthew Dwayne Tanner. And Mr. Tanner, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with his representation of you? Do you feel like you've had enough time to discuss your case with him and have all your legal questions answered? Is there anything about the paperwork that you've read and signed today that you do not understand? Mr. Schmidt, do you believe your client to be competent today? And you've explained to him his legal and constitutional rights? Mr. Tanner, you're charged by indictment with a third-degree felony offense of unlawful possession of firearm by a felon, which carries a range of punishment of not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice and a fine not to exceed $10,000. That being the range of punishment, I see here that you have reached a plea agreement with the state of Texas that you're asking the court to approve today. The agreement is that you plead guilty to that offense in exchange for the recommendation that your punishment be assessed at 10 years confinement in TDC, with that sentence being suspended and you being placed on probation or community supervision for a period of 5 years. You would have a $1,500 fine. You would have a weapon forfeiture. You'd have to reimburse Van Zandt County $785. And you'd also have to pay court costs of $290. Is that the plea agreement you want the court to approve? And that's your recollection as well, Mr. Schmidt? All right, very well. Mr. Tanner, then how do you plead to that charge? And are you pleading guilty because you are guilty of committing that charge? Has anyone threatened, forced, or pressured you to plead guilty? All right, the court will take the defendant's plea, we'll find that the defendant has intentionally, knowingly, voluntarily entered a plea of guilty. Mr. Schmidt, any objection to State's Exhibit 1? All right, State's Exhibit 1 is admitted into evidence. The court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, we would rest.
From the defense? All right, the court's going to review the evidence. All right, courts reviewed the evidence, find that there is sufficient evidence to convict Mr. Tanner of this offense. Court does follow the plea agreement in this case, convicts Mr. Tanner of unlawful possession of firearm by a felon. Court assesses his punishment at 10 years confinement in TDC. Will suspend that sentence, place him on community supervision for 5 years. Court assesses a $1,500 fine, $750 reimbursement fees, $290 court costs. Court orders the forfeiture of the weapon involved and used in this case, that being a Springfield Armory XD 45 caliber firearm. Court hereby forfeits that to the Van Zandt County Sheriff's Office. All right, Mr. Tanner, you're hereby remanded to the custody of Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm going to have you step forward here with the bailiff to be fingerprinted. After that time, I want you to step back here and meet with the probation department, and they'll give you additional information. Yes, sir. Thank you. Thank you. Thank you. Mr. Ashmore, are you ready? Understand. Who are you ready on?
Ms. Fowler and Mr. Aaron are both ready to run.
Ms. Fowler? CR 2333 and 334, set for docket call.
Good morning, Judge. We have a agreed request to for evidentiary hearing or for the plea. We just state the offer for the record. It's 20 TCJ based on her Ms. Fowler's prior history. And the state has provided all discovery, but in the last 20 days, we have been provided from Ms. Fowler's family evidence of some mental health and physical health things that have raised concerns not only about this, about her ability to make a rational, competent decision in this matter, but even possibly her last plea, which she made with her attorney, Gil Alton, I believe it was in October. So we're asking the court to allow us some time to get that information together, also to set this for an evidentiary hearing on our motion for mental health evaluation, which my colleague also filed this morning, and get us back here as quick as we can on that.
I haven't seen the motion for competency evaluation. Is this here?
It's just,
Emails to all of this, and then they just say it's opposed to that request.
Is the motion supported by an affidavit?
it is not because the legislature changed the law and has decided, I guess, in their wisdom, has decided to make these less burdensome for defense counsel when the issue is raised. If the court needs an affidavit, it's supporting documents, I can absolutely amend it, because I, like I said, recently been given some matters that are protected HIPAA matters that we file with designation under seal, so the court can review them or bring them to you in camera.
So you're saying the law's been changed in 46B to delete the supporting motion,
That's
supporting
my
affidavit?
understanding. And if I'm incorrect, I'll ask the court some leeway so I can amend it. But my understanding is the affidavit requirement is not, it is no longer required.
I'm just reading 46B004. Says that a motion suggesting that a defendant may be incompetent to stand trial may be supported by affidavits setting out the facts on which a suggestion is made. So that's what this court requires on all of its, unless it's on the court's own motion or it's apparent and obvious. I've not seen that from Ms. Fowler myself. So the court's not doing anything on its own motion. So I would like for counsel to support it with an affidavit setting out the facts on which I can read the motion, but before I pay a psychologist or psychiatrist $500 to $1,000 to evaluate her, I want to know exactly what the reasons are. So what I'll do is I'll reset this for a docket call, and then in the meantime, allow counsel to file that motion suggesting or supporting the motion for competency evaluation.
Yes, sir. I'll amend that. Again, it looked to me like it was no longer required. But we're happy.
Well, it's not.
We're happy to do that.
Well, it's.
We have the documents and support the testimony.
Well, I don't think it's ever been a requirement. It's this court's policy, I should say. It's not a requirement under the law that it's happened, but it says that it may be supported. So my policy is before I just pay $500 to a psychiatrist and put that on the taxpayers, that I have sufficient grounds to believe that it's necessary. And what I just asked counsel to do is to support their motion with, non-privileged information that you are aware of, either through your negotiations or, previous hospitalizations and things of that nature. All right, so we'll reset Ms. Fowler then. I'm assuming the state, I think you said you had no objection. So the court will set Ms. Fowler for an additional docket call and status on a motion for competency evaluation. Mr. Ashmore, have we discussed your calendar at all in July? Are you out at all in July?
Are you mentioned?
I'm looking at July 1st and July 8th.
Looks good, Your Honor.
All right, we'll set Ms. Grace Fowler then for docket call on July 1st at 9 a.m.
Thank you very much.
Thanks for printing that. Hey, Patty. You're welcome. All right, who are you ready on next?
Mr. Herron.
Mr. Herron. Kobe Herron, CR 18263.
Yes, Judge, this is a motion to adjudicate or revoke probation. We have been provided the state's list of deficiencies in its current probation. And we do not yet have an offer to resolve the on behalf of the defendant. We've made some requests regarding reinstatement, which the state is considering. We're just asking that we be reset on a contested so that the state and the defense can continue to work together to resolve this in a favorable way.
All right, court will set Mr. Herron then for contested hearing on June 29th. at 9 a.m.?
June 29th.
Yes, sir. This is a question. Or you're just telling me the time. Put that on the wrong one. Mr. Herron, you're still on probation. Still have to report, pay, drug test. Nothing's changed other than they filed a motion, okay? So that doesn't relieve you of those requirements, okay? All right, free to go. Mr. Ashmore, are you ready on anyone else? I can call Mr. Harper while you're doing that.
I would appreciate you.
Sharper. Your client, they're at the podium, and then you can just stand up here, Mr. Harper. This is CR 2291, State versus Kyle James Holland. Mr. Holland, if you will, raise your right hand. Mr. Holland, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. You are Kyle James Holland, correct? And Mr. Holland, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Aaron Harper. Are you pleased with his representation of you? Do you feel like you've had enough time to discuss your case with him and have all your legal questions answered? Is there anything about this paperwork that you've read and signed today that you do not understand? Mr. Harper, do you believe your client to be competent today?
Yes, sir.
And you've explained to him his legal and constitutional rights?
That's correct. Yes, sir.
Mr. Holland, you are charged by indictment with a third-degree felony offense of driving while intoxicated, third or more. That carries a range of punishment of not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice, and also a fine not to exceed $10,000. Do you understand that full range of punishment?
Yes, sir.
Mr. Holland, I see that you want the court to approve a plea agreement today wherein you would plead guilty to that offense. And the state recommends that your sentence be assessed at 10 years confinement, with that sentence being suspended and you being placed on probation or community supervision for a period of 5 years. As conditions, you would also be ordered to pay a $3,500 fine, $290 court cost, $60 restitution, $35 reimbursement fee. Is that your understanding of the plea agreement? Yours as well, Mr. Harper? All right, then, Mr. Holland, to that offense, how do you plead? And Mr. Holland, are you pleading guilty because you are guilty of committing that offense?
Yes, sir.
Has anyone threatened, forced, or pressured you to make you feel like you had to plead guilty? The court will accept the defendant's plea of guilt. Mr. Harper, any objection to states 1, the stipulation of evidence?
No objection.
All right, states 1 is admitted into evidence. The court takes judicial notice of the defendant's judicial confession. Anything further from state?
No, Your Honor, we were.
I'm just going to take a moment and review the evidence, Mr. Holland. Is there a lab in this case, state, you know? It was a blood lab.
Yes, Judge Lewis.
Okay, please.
Laboratory results.
Any objection, Mr. Harper? All right, there being no objection, court will include the Texas Department Public Safety Laboratory for the blood test in this case. All right, based on the court's review of the evidence, I do find that there is sufficient evidence to convict Mr. Holland of this offense. Court does follow the plea agreement in this case, convicts him of the third-degree felony offense of driving while intoxicated, third or more. Court assesses his punishment at 10 years confinement in TDC, suspends that sentence, places Mr. Holland on 5 years community supervision, orders him to pay a fine of $3,500, $60 in restitution, $35 reimbursement fees, and $290 court costs. All right, Mr. Holland. What's the next step for you? What's the next step for you? But what does that mean for you? Are you getting help with your addiction? You have kids? You married? You work? Got parent? You own your own business. Are you key to that business? What's that business going to do with you if you're locked up? They're not going to let you run it from TDC. Trust me, I've tried to send stuff down there. They won't even let inmates access emails. You got parents? Mother. She love you? You spend time with her? You want to do that through glass or bars? Very important. I see a pattern here with you. I hope that the pattern doesn't continue. All right, Mr. Holland, you're hereby remanded to the custody of the Community Supervision Department so they can carry out the terms and conditions of the sentence. I'm gonna have you step forward, be fingerprinted on the judgment. After that time, step over here to the left, Officer Matura, and she will give you additional information. Thank you, Mr. Harper.
Yeah, thank you.
Go ahead, sir. Ashley Olds, CR 2302. Good morning. Ms. Olds is set for docket call today.
Yes, I'd like to continue having some more time to see if I can work something out with the prosecutor. In this case, we get a reset, say 60 days from now.
What have we done between arraignment and now?
Not a whole lot, Your Honor. I've been swamped and I don't even think we've really had much communication before today. However, I've actually been working with the prosecutor a lot in the city. So I didn't waste the entire time.
Here's my concern. This is our third setting for docket call. We were arraigned in December, pretrial in January, docket call in March, docket call in April. Now we're at our third one. I'm not going to grant 60-day reset.
I understand, sir. What does your trial docket look like? You said this trial would look like you go.
It's hard to tell, but I mean, we've selected what, 4 juries in the last 5 weeks, I think. So it's probable that it could be a year, a little over a year.
Tell you what, if you would give me one more set of 30 days, if I can get something worked out. If not, we'll just go and set the trial. Your permission, sir.
State.
Judge, we did just extend an offer to Ms. Olds. There's some extraneous situations that she's got going on that she needs to figure out. The court will set her for a final docket call at the court's pleasure convenience. Hopefully we can get this worked out. And if not, then we'll just get ready to go.
All right, give me just one moment. All right, I'll make an offer of my own. I'll tell you what, I'll consider resetting for a final docket call, but Ms. Olds is going to pass the drug test today. So I'm going to ask you, do you want me to drug test your client, or do you want to make a final announcement today? I'll give you a second to talk to Ms. Olds about that.
Okay.
Which means I'll set you for a final, but I'm going to drug test her today. And if she's positive, she's going to stay with me. If she's negative, she goes with you.
Okay, so the offer is no drug test and we set the trial today.
Or we reach a resolution today.
I'd like to go ahead and set the trial without the drug test, Your Honor.
So what's the offer in this case?
Judge, I believe it was 3 years of pretrial intervention and resolution to outstanding drug or intoxicated offenses that we're still waiting on. That's what would be upstairs, not before this court. We're in attention.
2-year PTI? 2-year pretrial intervention with a 1245 The other unfiled misdemeanor cases? Oh, plea to the DWI and then a PTI up here on this felony case. Is that right?
Yes, Judge. This whole is on.
He said your client's on parole at this time, and he was indicating to the court that the offer for your client, that your client would be rejecting today and would not be able to accept later, would be it was 2 years pretrial intervention, no conviction on this charge, with her pleading guilty on the misdemeanor DWI or DWIs, whatever it is.
To DWI first. Probably get a above that parole, that's what I'm trying to point to. I don't know what to say other than what I have, Your Honor.
If I set her for trial today, you understand that she doesn't get to take a plea later.
Yes, I understand. I think the problem though is that the offer I'm being given is a guarantee for her to go back to prison anyways. So I'm trying to do damage control, Your Honor, to be quite frank, trying to zealously represent my client and try to help her too.
All right, so your client rejects the pretrial intervention offer?
I don't think she rejects that. She rejects having the DWI being pled guilty to.
Right, but
Don't send her back to prison.
I don't have the DWI before me. All I have is the pretrial intervention. That's the only thing I can ask for her announcement on. So, but
If you would just give me a moment.
sure,
And I
sure.
think that the offer that we have on this case so far would not get her revoked, correct?
I can't advise you on that. I can't advise you what parole will do.
There's no guilty plea and you're not finding her guilty, correct?
On a pretrial intervention, I would not be finding her guilty. However, the state may not be willing to offer that if she doesn't
Okay, I get the feeling they would.
resolve the DWI.
Yes, sir. I get the feeling they would do that. I think they're working with me to try to help this young lady stay out of prison. She got 3 children. And I'm trying to help her get some help too, sir.
Yeah, the pretrial intervention it requires a plea of guilty, but I would not be finding her guilty, so she would have to judicially confess.
All right. Just give me,
Sure,
30
sure.
seconds, Sean.
Go ahead, take a few more minutes. I'm gonna take up a couple other cases. Nicholas Duberly. Mr. Duberly, this is CR 2160. You are charged with a 3rd-degree felony offense of possession of a controlled substance in penalty group 1, greater than or equal to 1 gram, less than 4 grams. That carries a range of punishment of not less than 2 years or more than 10 years confinement in TDC, and a fine not to exceed $10,000. Is it my understanding that you're trying to retain an attorney to represent you?
I've already talked to my,
Did you retain him? Have you already hired him?
I've already hired him for another. And I'm talking about this individual.
Yeah, Mr. Patton has not filed a notice of appearance, so I don't show him as your attorney. So what I'm gonna do is I'm gonna reset your case for just a short period, but if you've hired Mr. Patton, then he needs to be here. Otherwise, we're gonna move on without him. I'm gonna reset you until I'm gonna reset you to June 15th. So it's gonna give you some time to get in contact with him and get it worked out, okay? There's one there. Okay. All right, so Mr. Dubberly, the deputy is going to bring you notice of appearance. If you'll sign that, we'll give you a yellow copy. All right, free to go. You may. Tiffany Stevenson. All right, this is cause number CR 2311. Ms. Stevenson, if you'll raise your right hand. Ms. Stevenson, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can put your hand down. Ms. Stevenson, are you a United States citizen?
Yes.
Do you read, write, and speak English?
Yes.
Have you ever been diagnosed with any type of mental condition?
Yes.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning's representation of you?
Yes.
Feel like you've had enough time to discuss your case with him and have all your legal questions answered?
Yes.
Is there anything about the plea agreement today that you've read and signed in this paperwork that you do not understand?
Yes.
Mr. Manning, do you believe your client to be competent?
She is.
And you've explained to her legal and constitutional rights?
I have.
All right, Ms. Stevenson, court sees that you want the court to approve a plea agreement between you and the state, wherein you're going to plead guilty to a state jail felony enhanced offense of theft of property, $2,500 to $30,000, with the state's recommendation that your punishment be assessed at 4 years confinement in TDCJ, with that sentence being suspended and you being placed on probation for a period of 1 year. As a condition of your community supervision, you would be ordered to pay restitution in the amount of $7,430, court costs of $290, and reimbursement fees of $785. Is that your understanding of the plea?
Yes.
Yours as well, Mr. Manning?
It is.
Ms. Stevenson, the range of punishment for a state jail felony offense and the enhancement on that, is that increasing the, is it enhanced because of priors, or is it enhancing the punishment range to greater than state jail? To a third degree? I think the judgment ought to say third degree then, instead of state jail enhanced. All right, you've been charged by indictment with a third degree felony offense of theft of property, $2,500 to $30,000, which carries a range of punishment of not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice Institutional Division. and carries a fine not to exceed $10,000. Understanding that full range of punishment, how do you plead to that charge? And Ms. Stevenson, are you pleading guilty because you are guilty of committing that offense? Has anyone threatened, forced, or pressured you to plead guilty? The state has also included in the indictment an enhancement paragraph alleging that you have committed a prior offense. Have you reviewed that with your attorney, Mr. Manning? And if I asked you if the enhancement or the prior conviction contained in the enhancement paragraph, if I asked you if those were true or not true, how would you plead? You would be telling the court that your prior convictions are true as alleged? All right. All right, the court will accept the defendant's plea of guilt to the primary charge. The court will also accept the defendant's pleas of true to the enhancement allegations. Mr. Manning, any objection to states one? States one is admitted into evidence and the court takes judicial notice of the defendant's judicial confessions. Anything further from the state? From the defense?
Just briefly, Judge, my client will be making a payment towards restitution today as part of the agreement. She does have that payment. We'll make that today to begin her payment of restitution.
Thank you, Mr. Manning.
State will get a new front page tax judgment with the punishment range correct.
Okay, thank you.
Judge, you covered that, the trust.
Thank you. Thanks, sir. Appreciate it. All right, Ms. Stevenson, based on the court's review of the evidence, I do find that there is sufficient evidence to convict you of this offense. Court will follow the plea agreement in this case. Court hereby convicts you of the third-degree felony offense of theft of property, $2,500 to $30,000. Court finds the enhancement paragraphs to be true. Court assesses your punishment at 4 years confinement in the Texas Department of Criminal Justice. Court will suspend that sentence and place you on community supervision for a period of 1 year. Court orders you to pay restitution in the amount of $7,430 to the victim named on the judgment. Court also orders you to pay reimbursement fees of $785 and court costs of $290. Ms. Stevenson, I find that 1 year is going to be a really small window for you to pay back a lot of what I consider a significant amount of money. You understand? And I'm just assuming that you and Mr. Manning have talked about that and that you entered into this agreement with full expectation that you can do what you're supposed to do. All right, so The time is ticking right now, and so you've got a short window to complete your probation conditions, your community service, pay back Van Zant County, pay the court costs, pay the restitution to the victim, do everything that you're supposed to do in probation. Understand? It's a small window, but it's a big sentence of 4 years hanging over you if you don't get it done in 12 months. Okay? So it's going to take you being accountable and responsible.
Just for the record, she had provided a budget to me of her income as well as expenses, and how she has to take that assistance.
Good. Let's hope that she's able to stick to that budget. All right, Ms. Stevenson, you're hereby remanded to the custody of the Van Zant County Community Supervision and Corrections Department so they can carry out terms and conditions of the sentence. Have you step forward here to be fingerprinted with the bailiff. After that, I want you to report to probation.
The gentleman that's in front of us is,
Do you have anything this afternoon?
did we have one of these?
Is that a writ? Is that a writ?
It's continuation of the previous file previously. We had agreement part. We've now got the whole. I'll send a report reflecting that to the DA's office. So you signature.
This is on Brandon Harrison, so we won't need to bring Harrison up.
And if you like, I can't go over there and speak to, well, then mine is shut down.
Yeah, Joe Boss. We can send message to him.
Judgment.
You may. You Shelton Vasquez. CR 1878. Mr. Vasquez, the state's filed a motion to adjudicate your guilt in your underlying criminal charge. Are you hiring an attorney to represent you?
Sir, I'm in the process of that now.
Tell me where you're at in that process.
I'm trying to get hold of Nolan Watts, so this morning I'll contact him later.
You feel like you're gonna be able to hire him?
I'm not 100% positive. I am requesting the request form imaging just in case I'm not.
I mean, what do you think though? Do you think you're likely to do it? I mean, you know what your finances
Well, I
are.
mean, I've hired it before. I'm doing it more by myself this time, so I just need to get into his office and try to work out some more details.
So if I reset you until say June 15th, feel like that'd give you enough time?
Yes, sir.
Yeah, I got one right. Thank you. All right, Mr. Vasquez, I'm gonna have the bailiff bring you this form here. You're gonna sign that and he'll give you a yellow copy and we'll have you come back on June 15th. All right, Mr. Vasquez, remember, you're still on probation. Still got to report, still got to pay, still got to pee in the cup. All right, free to go. Jason Nichols. Mr. Nichols, you've been charged by indictment with assault of a family or household member by impeding breath or circulation, a third-degree felony offense, has a range of punishment of 2 years to 10 years in prison and a $10,000 fine. Are you hiring an attorney to represent you? Did you go and meet with the court-appointed? She usually comes in here at the very beginning and makes an announcement. Step out in the hall, go to the very end of the hall. On your left, speak with Patty Taberham. You may. All right, back on the record, CR 2302, State versus Ashley Autumn Olds. Ms. Olds, if you'll raise your right hand. Ms. Olds, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you put your hand down. Ms. Olds, I have in my hand a document called Waiver of Jury Trial. Have you discussed this with your attorney, Mr. Crane? Do you understand that you have the absolute right to have your case tried before a jury of your peers? You understand that during that trial, you have the right to cross-examine and confront the state's witnesses and evidence that they seek to bring against you. You understand that you're the only one that could waive that right. Do you waive this right to jury trial knowingly, freely, voluntarily of your own accord? Has anyone threatened, forced, or pressured you to waive your right to a jury trial? Court finds that the attorney for the defendant, Mr. Adrian Crane, and the attorney for the state, Mr. Tyler Woodwalk, have joined in with Ms. Olds in requesting the court to approve the waiver of jury trial. The court finds that it's been entered into intentionally, knowingly, and voluntarily and approves the waiver of jury trial. Court will set Ms. Olds for a final docket call. Are you available on July 1st or July 8th, Mr. Crane?
Yes, sir.
Which one?
July 1st.
July 1st? All right, court sets Ms. Olds then for a final docket call on July 1st at 9 a.m. All right, once you sign the notice of setting form, leave the white copy here. You get the yellow copy, be free to go. Is Tony Curtis here? Mr. Curtis, step on up. Mr. Curtis, I called your case at 9 a.m.
Yes, sir.
You were not here.
No, sir.
I wrote down arrest Mr. Curtis. Wrote it right here. You want to see it? Right there. Should I just go ahead and, he's got handcuffs. Should I just go ahead and get him to do it now?
Well, no, sir. Slip my mind out. Don't get out. Women's and public pay. As I put them in the brings, my boss will call me. Somebody knows,
Are you gonna hire an attorney to represent you on your case?
I have been to hire an attorney, I'd say, it's been a pretty rough part of the, ESL section. You know, $41,000 a day right now, so it's just, we kick off pretty fast to June, July, so. It's,
Six months. I'm glad you said that. You've been charged with a state jail felony offense of possession of controlled substance. That same 6 months is included in the range of punishment, not less than 6 months, not more than 2 years, and a $10,000 fine. No parole, day for day. That's what you're charged with. So are you requesting a court-appointed attorney, or are you gonna hire one?
I'm able to hire, I'll be able to hire.
All right, I'm gonna order you back on June 15th. It's as late as you can go since you showed up late to court today. If you would have been here at 9 o'clock, I might have given you more time. All right, so I want you to come back on June 15th, and if you do not have an attorney hired, then you need to bring me the names and phone numbers of at least 5 attorneys that you've talked to between now and then. All right. All right, Mr. Curtis, deputy's gonna bring this to you. I need you to sign this. It'll give you your new dates, and then we'll give you a yellow copy and you'll be free to go. Miss Powell, are you a United States citizen? Do you read, write, and speak English? Ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Casey Ashmore. Are you pleased with his representation? Do you feel like you've had enough time to discuss your case with him and have all your legal questions answered? Anything about the paperwork that you signed and read through today that you do not understand? Mr. Ashmore, do you believe Ms. Powell to be competent today?
I do, Your Honor. This is signature block. So, just so the court's aware, this is a state jail felony enhanced because of the pandemic. And we've reached a plea offer for 10 years TDC, probated for 4 with a fine of $2,500, restitution of court costs. We're asking the court to approve that today. Just want to address all the subject.
Yes, sir. Go ahead.
We're ready, Your Honor. Thank you.
All right, this is CR 2187, State versus Jason Nichols. Mr. Nichols has requested court-appointed attorney. The court has reviewed the information he's provided in the affidavit, finds him to be indigent, has appointed the Honorable Casey Ashmore to represent him. Mr. Ashmore, have you had an opportunity to consult with your client regarding the arraignment and the indictment in this case?
Yes, Judge, my client understands that he's charged with a third-degree felony under the assault statute, family violence, eating breath, and that his name, Jason Eric, spelled E-R-I-C-K, Nichols, spelled N-I-C-H-O-L-S, is spelled accurately at every point in the indictment, and has authorized me to make a plea of not guilty so that we may start working with the state for its resolution of this matter.
All right, the court will enter Mr. Nichols' plea of not guilty into the record and will set pretrial on July 1st at 9 a.m. Mr. Nichols, you're going to sign that notice of appearance. Have you also had conditions of pretrial release presented to you? So you understand, okay, so you understand that you're going to have to report, you're going to have to pay supervision fees, and you're going to have to pay towards your attorney fees. Okay. And you'll need to come back after you sign that, come back and meet with Ms. Burns, sign that form, and then you'll be free to go.
We said July 1.
July 1, yes. Ma'am, who are you with? Okay, thank you. Ms. McGahee, if you'll step up here to the podium. Is it McGahee or McGehee? McGee. McGehee. Officer Matura, will you see if Ms. Burns is available? All right, this is CR 2183, State versus Tracy Renee McGee. And I believe I asked pretrial supervision to conduct a urinalysis exam with Ms. McGee.
Yeah, she admitted to smoking meth yesterday, so just under the.
Ms. McGee, you know that's, yeah, you've left me with no choice, but I'm gonna find your bond to be insufficient at this time, and I'm gonna order you into custody.
And very
court is finding the personal bond of Tracy McGee to be insufficient for violation of the conditions of pretrial release for admitting to the usage of controlled substance methamphetamine. All right. Yes, ma'am. All right. The court finds that the following individuals' names were called in the courthouse, in the courtroom specifically at 9 a.m. with no appearance. Ashley Faye Dover. Alex Manes, CR 2182. Cannon Rackow, CR 2189. Brendan Chumley, CR 2151. Kristen Lewis, CR 2181. Billy Gammons, CR 2164. That's all that I have. Ms. Heisler. Is that right? Okay, I'll have their names called in the courthouse. Yes, thank you, Mr. Wright. Will y'all be here? Or y'all be there?
We'll be on Zoom.
You'll be on Zoom for the,
And you'll have Rachel for something.
Rachel will be there.
Yes. I'm gonna leave these with you.
Well,